Good morning and a happy Sunday to all of you. So thank you for joining us today. Today we're going to have, as usual, a great show for everybody. First of all, let's acknowledge Bird for becoming a new member of the Brother Counsel Sidebar. Appreciate that, Bird. Way to start off a Sunday morning here in Michigan. Appreciate everyone coming, and in the chat, I see it's very active already. So that's great. Start putting your questions in there. We're going to have national trial lawyer, Brother Counsel, join us in just a minute. So we had a great week last week. Unfortunately, there was one day that there was no trial, just no trial last week on the day, supposed to be day 15. And it seems like Karen Reed was not feeling well. So it was a little bit less than a full week. And then this coming up week, I want you to know that Thursday is going to be a half day and Friday is going to be an off day. So a little bit of an extended weekend for all of you. So, but don't worry, we will be here every single day of the trial this week. I do have actually a court hearing one of the days, which I'm going to have to step away from, but don't worry, the live stream will keep going. And I'll just let you know that I have to run out for a minute and join the court, my own court hearing. So without any further ado, let's bring on Brother Counsel, national trial lawyer Solomon Radner, who is, by the way, celebrating his anniversary by doing a live stream with me today. So thank you for spending your anniversary with me here and the entire Brother Counsel community and family.
It's always an honor to be here, and I'm sure my amazing, beautiful wife will understand.
Yes. So don't worry, we're going to get you out of here as soon as we can after we make sure we take the questions and talk about the relevant topics, and then you guys can go out and do whatever it is you have planned to do today. So let's jump right into it. Actually, you know what? Before we jump into it, there's been some comments and questions about, because you made a mention about the Casey Anthony case, and I'm not entirely familiar with the Casey Anthony case, and some people have been asking, to just get a little bit more of a broad understanding of what your opinion is on the Casey Anthony case. And apparently she's making some news now with her new channel or her new activities, whatever she's doing now. So seems like she's coming back up in the news and people are discussing her case. So you said a comment about this last week. So why don't you expound a little bit about what you believe happened in the Casey Anthony case and whether you think the jury got it right, whether it was the right verdict. Go ahead, take it away.
The Casey Anthony case, this goes back a long time, probably, I don't know, quite a bit. And I remember watching it in real time, and I remember watching it. It was one of the first trials that I watched pretty much, by way of watching on TV. When I was in law school, I used to go to trials and watch trials, but this was one of the first trials that I actually watched through the internet. And I remember thinking to myself that the prosecution did not prove its case. And I remember bits and pieces of it. I remember that there was never any point in the trial where there was any sort of direct evidence of a murder. And I don't remember all the details of this case. I know that she was found guilty of a couple of misdemeanors, and that she ultimately was sentenced to mainly time served and then got out a little while later. But I know that she was found not guilty of murder, and I don't know what other charges there were. But it was a very sad situation where her baby died. There's no question about that. And they found her baby's body, I think, a few months later in the woods or in a forest or in the mountains or something. And there was just very little evidence proving a murder. They could have proved death. There's no question about that. And they easily proved that she was not honest with the police. But just because somebody is dishonest with the police about a dead body that's found that's related to them, this is going to sound a little bit like our case here today, that doesn't necessarily prove murder. Like, the way that I would apply what happened in that case to this case is if you try to say that the people inside of 34 Fairview murdered John O'Keefe, I think you definitely have enough evidence to probably charge them, to establish probable cause. But the question is, by virtue of the fact that there's a dead body found there and they're clearly not being truthful with the investigation, does that mean that they murdered him? And I think that's ultimately the same question that was presented in the Casey Anthony case. And there just was not enough evidence of murder. It was a completely circumstantial evidence case, and it was a very sad, tragic case. And it's one of those situations where, and I did this once, every once in a while, you kind of look at the jury and you say, you may think my client's a monster, you may not like my client, and you may even think my client's guilty. That's not enough to find her guilty. You need to know beyond a reasonable doubt. And that case was full of reasonable doubt.
Okay, so I guess you're saying the jury got that
situation. Right. I think the jury got that one right. And I could go back and look and review all the evidence again if you want to do a full show on it. But those were my thoughts at the time. I just remember thinking at the time that there was not enough evidence presented to convict her. There just wasn't.
Okay, so moving on to the Karen Reed case, and of course, everyone, as you know, we don't have Solomon here for too long. Hopefully, we'll have him. We'll squeeze him as much as we can for everything that he's going to give us today. But if you got any questions, start putting them in the chat so we can get to them as soon as possible. But I know that everybody really wants to get your take on two main issues that happened in last week during the trial. Okay, so the first one, which is really what caught everyone a little bit by surprise here, Judge Cannoni generally comes in every morning and asks the jury 3 questions. And, have you discussed this case? Have you spoken about this case? Have you read about the case? Things like that. Okay. And all of a sudden on Friday, she added some more comments to her normal questions. So I'm going to play it. This is something that I've never seen in any of my cases. I know that there are some times that you and I know the judge sometimes has to, say something to the jury that they should disregard something, or, occasionally there's some comments or other questions. But listen to this, because I think it kind of stuck out to me, and you'll tell me what your take is on her little speech here. All right, I'm going to speed it up just a drop so we can get through it a little bit faster. But we're going to start from the beginning of her questions, and then we'll see what she says at the end. Then you'll tell me what you think about it.
So I appreciate your patience. I have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. I have one other important instruction for you folks, and it's so important that each and every juror can hear the evidence or the testimony that's presented, can follow the testimony, and can understand and evaluate the testimony of each witness and the exhibits. In order to do that, I just want to be very clear that it's important that people do not comment on the evidence or make any comments. Once you enter the room, it's probably a good idea to just listen. Don't talk. Don't make any facial expressions. No muttering under your breath. No audible noises, because people need to hear what's going on and to understand everything. So out of respect for your fellow jurors, I would ask that you be very careful to make sure you don't do that. And out of respect to the lawyers who work so hard to get this case moving. Okay? Thank you very much. With that, Mr.
Well, that's it, Solomon. So what is your take on that little speech there?
Well, let me ask you this, because I saw that clip over the weekend. It made me laugh. But my immediate question is this, and I don't know if you know the answer to this. Who was the witness that testified before that instruction? The last witness to testify before that instruction?
You know something? You know what? It may have been. Oh gosh. Here, I'm gonna wait. I think that was beginning of day 17. So day 16, the last witness was Scorti-Bello. Scorti-Bello was the last witness on day 16. That was the medical examiner. So here's ultimately the question. The question is, what were they laughing and smirking at? And I know that I've had cases like this where it just feels like from beginning to end, the jury is either on your side or not on your side. And I've had both. And when they're not on your side, you can kind of tell. And it's really hard to get back a jury after you lose them. They call this, I spoke about this in one of your earlier videos, but sometimes what a jury will do very early on in a case, as early as the jury voir dire or opening statements, is they'll do something called the halo effect. They'll put the halo on one person and they'll put the devil airs on somebody else. And once they do that, it's virtually impossible to take them off, because everything that juror will hear after that
after they assign Halo and Devil Airs, once they assign that, everything that they hear internally, whether they try or not, they're going to assign credibility based on what they believe the end result should be. And that's just sometimes something that happens. And it's sometimes, you know, I'll be trying a case. There was one murder case I remember that I tried for an entire month. There was no chance in the world of winning this case. There just wasn't. But we had to cross all T's, dot all I's. I cross-examined the hell out of every witness I could. You know, I did my job. I absolutely did my job in that case. And it was a solid month of absolute war. At the end of the day, the jury found him guilty of 2 out of the 3. And he was sentenced to life without parole. The reason we went to trial in this case is that the prosecutor was offering a plea of, I think, 60 to 100, and the guy was already in his late 60s or mid 60s. So he had no reason to take the plea because he knew it was life in prison anyway. So
Death in prison.
Yeah, death by cell, death by prison cell. So that was a case where I saw during my cross-examination of the witnesses, I would see out of the corner of my eye that sometimes jurors would be smirking. And I'd just be like, oh, this is not good. You know, but it is what it is. It's kind of like a tell. And as a lawyer, you kind of want to know what the jury's thinking so that you can try to get them back. So sometimes you're lucky and they let you know what they're thinking. Now, in this case, I have seen a lot of claims that I would categorize as laughable. Okay. If I were a juror in this case watching some of these claims that the prosecution is making and some of their witnesses are making, I'd probably have a hard time holding back my laughter as well. I have not seen anything from the defense that would be worthy of getting laughed at or smirked at. I just wouldn't. So based on that instruction, you got to wonder how the prosecutor feels at this point, because I think we've seen their strongest evidence. And just from seeing what I've seen, based on the evidence that I've seen and based on what I think is the strongest evidence that the prosecutor has shown, there's no evidence of guilt at all. In fact, I don't even think the judge should let this go to a jury. I think that this case should be, it's something called a directed verdict, because in order for the judge to allow the jury to even consider the case, the judge has to decide whether or not any reasonable trier of fact could convict. And what evidence is there that you can convict based on that evidence? I don't see it. I really don't. And we could talk about this more if you want, but I think that the prosecutor has a really tough road ahead of them. I think they probably have quite a few more witnesses to go. And I think that instruction can only be viewed as that the jurors are laughing at the prosecutor, because I don't see how they could be laughing at the defense.
So I'll
be one heck of an uphill battle for them.
So I'll play a little bit devil's advocate here. Okay, this is what I like to do with you anyway. So I'm going to take the prosecution side right now. So you know, understanding that a directed verdict, you have to view all the evidence in light of the non-moving party, all the evidence and inferences in the light of the non-moving party, which would be the prosecution of the Commonwealth in this case. So if we take all those inferences in their favor, so for example, the fact that they have a few people saying that they heard Karen Reed saying affirmatively, I hit him, not in a question form. They also have 46 pieces of taillight found around the scene. And again, assuming inferences in the favor of the Commonwealth, which would mean not to assume that they were planted there or anything. So you'd have to infer that they somehow ended up there in favor of the Commonwealth. Then you also have a piece of glass on the bumper, and you have a piece of John O'Keefe's hair with his DNA on the back of the Lexus. Now, again, I know that all the arguments, but viewing the evidence in the light most favorable to the Commonwealth, and then we are going to have also some testimony from Jud Welch, who's going to somehow explain how this accident could have happened in the world of science and physics. Now, we haven't seen him yet, but I'm assuming he's going to make that claim, and therefore, again, viewing that in light of in light of the favor of the Commonwealth, would you say that would at least get to the jury?
Okay, my answer to this is still that if you look at all the evidence, even in light most favorable to the prosecution, there's still no juror who can convict beyond a reasonable doubt. Look, there's enough to establish probable cause, maybe. There's not enough to convict beyond a reasonable doubt, and I think as a matter of law, the judge should make that determination. Again, this is based on the evidence I've seen so far, and assuming we've seen the strongest evidence. I hit him. You have to look at that as a whole. Okay, you can't just look at words in isolation. The testimony from the witnesses who claim years later that she said, I hit him, also claim that she was frantic, that she was yelling, that she was asking, did I hit him? So you have to ask yourself, would any reasonable trier of fact believe that she's frantic and hyperventilating and freaking out and asking, oh my God, did I hit him? Do you think I hit him? Hey, do you think I could have hit him? Do you think I hit him? I hit him? Did I hit him? That's how it sounded. Maybe she uttered the words, I hit him. It was not like this. I hit him. And then back to the freaking out of, oh my God, did I hit him? There's just no reasonable, plausible way of explaining the testimony as a whole. And there's no witness who got up and said, I heard her say, I hit him. And then that's it, nothing else. Okay, so if you look at any one of those witnesses about the I hit him claim, there's nothing there. All that happened here was, and this is, I don't see how you get around this. They created a suggestion where she believed she hit him. That's all there is to it. If you know, you can play on people's emotions in a number of ways. If you if let's say there's somebody driving a car and they run over a stick and they feel a bump, and then as they got out of their car to walk around, somebody comes and quickly puts a body there. They're going to look and they're going to be, oh my God, I hit this guy. But it was planted. And you have to look at all of this as a whole. If you look at all the evidence as a whole, even the I hit him, I don't see how this case gets to a jury. There is no evidence that a jury can convict beyond a reasonable doubt based on what I've seen so far. Mm-hmm. That's my opinion.
Okay. Well, I'll tell you that there were some reports that the reason why Judge Cannoni gave that instruction is because some of the jurors were smirking or laughing when Alessi was asking Maureen Hartnett, did you ever have to take swabs from a bloody-like material from Solo cups? And she said no. And then he said, since this case, have you ever taken swabs from a red Solo cup that's usually...
This is when they were laughing? This is what
there's been some reports that that's what they were laughing at. And that's why she felt the need. And again, I don't know if this is from sidebars that Brennan brought it up or somebody on the prosecution side, but something caused her to go and give that instruction to the jury. So, but that's what some reports are, that some of the jurors were laughing about that. And by the way, they haven't yet heard the worst of the texting of Michael Proctor yet. So they've heard some, they've heard some about the no nudes so far and the retarded going through the retarded client's phone. Let's just jump onto that right now because it has to do with Buchanan, which was the first day of last week. So, going through that, he did a thumbs up on Buchanan. I'm sorry, I keep saying Buchanan, because people always get upset when I pronounce things wrong. So Buchanan said that he was part of this text message chain. And when Proctor said something about, funny, I'm going through his retarded client's phone now, talking about Yannetti, the defense attorney, he did a thumbs up. So he was asked, so Jackson said to him, you liked that message, right? And he said, well, I acknowledged it. So what do you think the jury was thinking about when he tried to argue with that? Doesn't everybody know what a like is?
I think that there was already nothing left of Buchanan when that question came out. The only way to describe what Jackson did to Buchanan is total obliteration. All right. By the time they got done with him, there was nothing left of him. He's not credible. He's not being truthful. He refused to answer questions. And there's going to be eventually, when the jury gets the case, there's going to be what I would call, if I were Jackson, the Buchanan instruction. So what did it ultimately do to his testimony? I don't know. But I don't think there was any credibility left of him by the time they got done.
Yeah, so everybody here is reminded to hit the acknowledge button as we're sitting here. But also, remember when I don't know if you caught this part because I know you were like in and out of the trial trying to watch, but there was a certain point when they were trying to talk about those text messages and Jackson was saying that wasn't professional. That didn't show any integrity, right? And then he tried to fight back on that. And you remember the Webster's Dictionary situation, you know, and then he says, well, you know, he does have a constitutional right, First Amendment, to say whatever he wants. So, well, what do you think about that response to, is this an officer who's acting with integrity? And he says, well, he has a constitutional right to say what he wants.
Well, there's two things about that. First of all, no, police officers do not have the constitutional right to say whatever they want within the context of their employment, just like nobody has the constitutional right to say whatever they want within the context of their employment. Okay, if you walk into your boss's office, if let's say you're a police officer and you walk into the chief's office and tell him to go use your imagination, okay, you can get fired for that. You can get disciplined for that. You're not allowed to say that to him, even though you have the constitutional right to say it. Fact of the matter is, you are not permitted to say things like that. It's unprofessional. It's violative of a number of rules of being a police officer, and you can get disciplined for that. And I've seen cases where they have been. So, you know, very often things that police officers say, they get disciplined for. I mean, you can use your imagination, but if let's say there's certain level of professionalism that's demanded on police officers, and if a police officer pulls somebody over for speeding and goes, good morning, sir, license and registration, please, a-hole, you can imagine that he's going to get disciplined for that, even though he has the constitutional right to say that. Okay, so that's number one. No, they do not have, yes, they have the constitutional right to say it, but in the context of being a sworn police officer acting in their official duties, they can absolutely be disciplined and punished for things that are constitutionally protected. That's all there is to it, okay? Because there's reasonable limitations that are put on what they're allowed to say in their official capacity as a police officer. I mean, an obvious example is you're allowed to wear whatever you want. You can wear whatever you want during the day. But if you show up as a police officer, instead of wearing a uniform and you're wearing a t-shirt that says "Go Lions," because we live here in Detroit, you can get disciplined for that because that's not how you dress to work, even though you have the First Amendment right to wear a "Go Lions" t-shirt. Okay, so let's just put that to rest. Number two, this whole thing about acknowledging it or liking it, there's just no reason to even argue that. This is something that if I were the prosecutor, I'd glance over as quickly as possible and move on. I would have done it in my direct. Just, you know, here it is. You gave it a thumbs up. Let's move on. That when the defense brings it out, it's just, yeah, I did. I gave it a thumbs up. Should you have done that? Probably not. That's it. But no, the First Amendment doesn't really apply here. And just so your viewers know, I have litigated the First Amendment in probably a dozen states.
Yeah, and actually, you and I tried a First Amendment retaliation case. Remember that?
Yes, we did.
Yeah,
that was the pro bono one. The judge asked us to jump in at the last second.
That's right. That's right. We had a good
lost
time
that one. It was close, but we lost.
Yeah, we lost it, but it was a lot of fun. But anyway, so the funny thing is about Buchanan is that what the prosecution needed from Buchanan was, you know, kind of like the person who's going to come in and save the day from the jury just deciding that Proctor's a piece of garbage and therefore the investigation's garbage. I feel like if I was a prosecution, I want Buchanan to come in there as a supervisor and say, you're right, Proctor did a lot of things wrong. He should have been fired. He acted with misconduct. It's not appropriate. I even made some mistakes myself, but the investigation was fine. And if he would have come across that way instead of fighting with Jackson with every single question that he asked, you know, I think they would have had a little bit of a better chance. But now, like what you said, it was 3 days of fighting, asking Jackson to bring a Webster's dictionary, talking about constitutional rights, refusing to answer questions. And then the jury's like, okay, you know, they're tired of him and they see what's going on. Like what you just said, you know, his credibility was destroyed. He doesn't look like he's honest. He doesn't look like he's forthcoming. So now who is the prosecution going to ask the jury, look, Proctor's no good, but I don't know, trust him. Who? You just destroyed Buchanan. He can't answer a question honestly. So who are they going to point to say, oh, he's the guy that we should trust in this case? So I think that what you're saying is that like the prosecution kind of sunk their own ship with Buchanan doing such a terrible job on the stand.
Right. Given that they can't use Proctor, you always have to have your main witness, your strongest witness. And who was that so far for the prosecution? McLaughlin? Jen? I mean, if you think about it, let me ask you, and maybe your viewers can tell us in the comments, who has been the prosecutor's strongest witness this case? I'm really curious. I don't know if you can put a poll up or anything, but I'm really curious who they think the strongest witness is. I think their strongest witness had to have been Buchanan, and he was obliterated, total obliteration, nothing left of him, no credibility, completely destroyed. By the time they got done with him, if you would ask him what time it is and he said 2:30, I don't think you could believe that it's 2:30. That's how little credibility this guy had left. So yes, I think the prosecution, I don't know if he refused to meet with the prosecutor or if he met with the prosecutor and he's just uncoachable. And look, some people have such an ego that they're incapable of accepting any sort of instruction. Okay, that's possible. But he was not a good witness for the prosecutor. And if he was their best witness, they got a real problem, because who else is going to testify as the police expert who is a part of the investigation? Usually it's the OIC, the officer in charge of the case, which in this case is Proctor. The only other one would be Buchanan. So who else do they have?
Right.
As a prosecutor, you want to put somebody up who can kind of take you through from A to Z and explain to you how we did everything right and all the evidence led to this, and this is where we are. And they can't do that now. They've got nothing.
Yeah, that's true. The truth is that I think the best witnesses so far for the prosecution, I mean, the ones that answered questions actually honestly and directly and like didn't look like they were playing around was Zachary Clark and Evan Brent. They actually got on the stand. It was actually relieving because they got on the stand, they answered the questions, and it was like, okay, this is like a breath of fresh air. But they obviously had very, very little to do with this total investigation. So it's not really going to help. It's not really going to help the prosecution that much.
But no. But what that does is that actually hurts the prosecution a lot, because it shows contrast of people who are able to answer questions and people who are not. The jury watched Jen McCabe and the jury watched Buchanan, and then they watched these two, and they're like, oh, wow, look at that. He answered a yes or no question with a yes or no. Why weren't these guys doing that? Why weren't they capable of answering a yes or no question with a simple yes or no?
Yeah.
So when you have that contrast right in front of you, it creates problems sometimes.
Yeah. Let's get to this question from Mr. Meathook. Given the Commonwealth's hostile attitude to date, why in the world would the defense stipulate at no proctor at autopsy when they didn't have to? I would have told them to pound sand. So, Solomon, I'm not sure if you're aware of this, but what happened is that there was a picture of two Massachusetts State Police who were at the autopsy. One of them was Connor Keefe. The question was, who was the other one? Now, there are logs which identify, signing in and signing out, and apparently Proctor was not one of the ones who signed in and signed out. So there was a question about who the other person was, and then what happened, and there's a lot of talk about this online, and then the very next day, Hank Brennan's a prosecutor, he read a stipulation that, the parties stipulate that the other person in the picture was not Proctor. So I think that the reason why they did that is because if it's not Proctor, it's not Proctor. So let's not make an issue out of something and put false seeds in the jury's heads, and then that be a basis for some issues down the road. It's not going to win you the case. It's just something that we all know is true. So if it's verifiably true, then may as well not fight it. That's what my take on it is. You don't have to fight everything.
I would tend to agree with you. There's no reason to fight every single thing. And more importantly, I can only imagine that at some point in time, there's going to be a defense witness who testifies about who they are, whether it's a police expert, an ARCA expert, some other expert, or maybe Michael Proctor himself. I mean, it will eventually come out that that's not Michael Proctor. And again, this is one of those things where you build credibility. If as the defense, you're going to fight that, then when it comes out that that's not Proctor, you look like a liar. You look like you're trying to misrepresent things to the jury. So why do that to yourself?
Right.
This way, you gain credibility. One of the most important things that happens during a trial, and this happens from the time you leave your house in the morning till the time you get home in the evening. Credibility, it's huge. There was one time somebody who told me that he had a road rage incident with a juror during a trial. Okay? He told me he got to trial and he looked up and he saw one of the jurors was somebody that he had a road rage incident with him that morning. And I said, well, maybe next time you should just drive a little more carefully to court. If you know you got a jury trial, drive slowly, drive carefully. Don't be holding up your phone, because all you need is one juror to see that and be like, this guy's a moron. This guy's an idiot. This guy's a jerk. You can put on the best case, and then this juror hates you because of, you slammed on your brakes in front of them. So,
Right. Okay. Norris G says, why was Albert and Higgins' DNA not tested on clothes? Good question. They didn't test Albert because after all, they weren't suspects. So why should they test them?
Yeah,
Captain
sure.
Rhett Snuggler. You're right. Hit the acknowledge button, y'all. There we go.
This is one of those things where, there are certain things that you could technically say, maybe even try to say with a straight face, but if everybody knows you're not being truthful, why argue the point? You like that? Yes, I did.
Exactly.
Yeah.
Elf. No police officer made an accident report or documented in the report that she said she hit him. That's correct. And remember, we were talking about a directed verdict before, and what I was being devil's advocate, putting myself in the prosecution's shoes, is that you have to take all reasonable inferences in the favor of the non-moving party, which would be the prosecution in this case. So even though you're right, this is an argument that the defense can definitely make. But if you do have witnesses that say that they heard her say that, you can argue to the judge, then all reasonable inferences from this witness testimony should be taken in favor of the prosecution, and therefore, they should assume that she actually said that, even though it's not in any report.
It has to be credible testimony upon which a reasonable trier of fact could conclude guilt beyond a reasonable doubt. I don't see that. Let's say, for example, that there's a witness who gets up and says, I heard her say, I hit him, I hit him, I hit him. And then it's proven later that witness, let's just kind of, let's pretend for a minute. Let's say there's one witness who says that, but you're able to prove conclusively without any question at all that witness was actually in Zimbabwe at the time. Okay? You're able to prove it with pictures and videos and cell phone data and acknowledgments and Facebook posts that witness was in Zimbabwe at the time, not in Massachusetts. Okay? Even though you have that testimony that she heard her say, I hit him, I hit him, I hit him, it's not credible. You can't conclude beyond a reasonable doubt. My position here is that testimony to hang guilt on is so weak that no reasonable trier of fact could conclude guilt. That's it.
Mm-hmm. Okay.
In fact, I think at this point, the worst thing going for Karen Reed is her own words. The fact that she keeps talking to the media, I don't think it's helping. I don't think it's doing what she thinks it's doing. And I'll tell you, one of the strongest things that I've heard so far is those voicemails. Those voicemails are not somebody who just killed somebody. They're an angry, upset partner of a man who is either out drinking with his buddies or having an affair.
Yeah,
in my opinion.
I mean, it was very raw. So
Not to go off on a tangent.
Yeah, very raw. I mean, somebody actually asked why she just recently stopped talking to the press, which is all right. Good. She should stop talking to the press already. Elf became a new member. FSU MSW 93 became a new member. Z has the following question: can Yuri Buchanan's First Amendment defense benefit Turtle Boy's charges? Well, all right. So Turtle Boy's charged with witness intimidation. It's a whole different statute. It's a whole different statute. It's a whole different. Whether your First Amendment is protected it's not protected to intimidate witnesses. Okay, it's a whole different analysis. Let's
just be clear about this. The First Amendment does not guarantee absolute free speech all the time. Okay, for example, you can't go over to somebody and say, "I'll give you $1,000 if you murder that guy." All right, that's solicitation for murder. That's a crime. You can't go over to a prostitute and say, "I'll give you $100 if you whatever." Right, that's solicitation of a prostitute. Okay, there are certain things you're not allowed to say because they are criminal acts. Okay, so. Witness intimidation, if you go over to a witness and say, if you testify, I'm going to kill you, that's not protected by the First Amendment. That is speech. That is criminal. And it should be.
All right. Nurse Kimberly from the Sunflower State says, can the defense say the ARCA is from another agency since they cannot hired from FBI? They can't say they were hired by the FBI.
Right. So that's a bad ruling. That's one of this judge's bad rulings. That's all there is to it. They should absolutely be allowed to say who hired them because it bolsters their credibility. And it kind of undercuts the prosecution's implicit claim that they're only testifying a certain way because they're being paid by the defense. Okay, so I mean, just like if there's a prosecution witness, let's say the prosecution hired an expert. I actually had this happen in a case one time where the defense hired an expert and halfway through the case, they changed their expert and they changed that expert to a consultant. And I filed a motion that I wanted to take that expert's deposition. And they objected and said, no, you can't take his deposition. He's a consultant, and consultants are different than experts. A testifying expert, you're allowed to take their deposition. An expert consultant is somebody I'm just consulting with who's not going to testify. That's basically a part of the legal team. And just like you can't take my paralegal's deposition, you can't take my consultant's depositions, okay? So I wanted to know why they suddenly changed this guy from testifying expert to consultant. And I found out why pretty quickly. After we had a very a good battle in court, I won the issue, noticed up the deposition, and before we had a chance to take the deposition, we settled because they knew what was about to come in. Okay, now I'm going to tell you right now, the very first thing I would have said to the jury, I would have called that expert in my case and I would have said, how did you first get involved with this case? I was retained by the defense. And then at some point you were switched to their consultant. Tell us why. Well, I was going to find A, B, and C that, that against the defense. So they changed it. And now you're here testifying and I'm paying you to testify now, but you were originally brought into this case and paid by them. Is that right? Yes, that's right. That's how I would present that. So it's no different here. There's no reason in the world that they're not allowed to say that they were hired by the FBI. It's improper. It's another one of her improper rulings.
But the fact remaining that even though they cannot say that, I'm sure they're going to be allowed to say that initially they were retained by an independent agency or independent of the defense and Commonwealth. So they should be able to say that. I don't think she made a ruling that they can't say that. So they will be able to say some sort of thing like that, and then they had to retain them for this trial. But there should be something like that. Now,
I think at the very least, and this would just be the most absurd ruling she's ever made, even with those experts. That absurd ruling. If she doesn't even allow them to ask the question, when you first got involved in this case, I did not hire you. Is that right? When you first got involved in this case and wrote this initial report,
right,
you were not being paid by anybody on behalf of the defense, correct? If she doesn't even allow that line of questioning, it's just completely improper and would just be another completely asinine ruling. But hopefully she will allow them to do that.
Right. And they should be right. Exactly. And they should be able to say that when they performed their reconstruction and their testing, they were not retained by the defense. So let's get into this question because really I wanted to segue into this next area also, which a lot of people are really dying to hear your opinion about, Solomon. Two issues that came up at the end of the day. Not sure if it was it day 15 or day 16? Let me just check my notes for a second. I think it was day 16. At the end of day 16. So here's the question. I know a lot of people have been asking, how many times by now would Solomon have moved for a mistrial? So the answer is, probably every day, but or maybe multiple times a day. But here's the question from Jay Coop. Do you think defense should ask for mistrial with prejudice after Judge Cannoni's bogus last two rulings, at least put on the record? How would you handle it? This is clear sandbagging. So Solomon, before you answer anything, I want to show you what happened in court at the end of the day one day. And now let me just kind of set the stage before we play the clip. Okay, you're familiar with ARCA in this case, and right?
Yeah.
Okay, you're familiar with ARCA. You're also familiar with Ian Whiffen, right? So Ian Whiffen is one of their digital forensic tech experts who works at Celebrite, and he developed his own app, and he testified about this Google search wasn't done in 227, but he also testified extensively about the use of John O'Keefe's phone, the location data, the health data, the temperature of the battery temperature data, the pocket data, all this type of data he testified on the phone, and he created a timeline. And in this case, seconds matter. They really, really matter in this case, which is why sometimes I feel like 12:31 and 16 seconds, this is what happened. Yeah, you actually need to know that in this case. So seconds matter in this case. The fact is that Karen Reed connected her phone to John O'Keefe's house at One Meadows, which is about, I think, a 6-minute drive from 34 Fairview at 12:36. Okay, now the Commonwealth's case here is that this collision happened at 12:32 and 16 seconds. Okay, that's the Commonwealth's case, and they had Ian Whiffen kind of supporting this by showing the different data points in John O'Keefe's phone. Okay, now the prosecution is going to call these two other experts. One of them is Jud Welch, who's going to testify about reconstruction. He did a reconstruction to basically contradict the ARCA experts. He's going to show how this is all possible in the world of physics and science. They also have this other guy, Shannon Burgess. Shannon Burgess, apparently, and again, we haven't seen him testify, and I haven't seen his report, so I'm just going on what I hear in court. It seems that Shannon Burgess, who also works for the same firm as Jud Welch, is going to testify about the Lexus data, the black box data, the text stream data, and he's also going to create some sort of timeline. Okay, now these this investigation and these reports were already written a while ago. Ian Whiffin's report was written. Everything was written already a while ago. Now, what happens here is that all of a sudden, on May 8th, there is an amendment to Shannon Burgess's report, and he kind of changes the timeline. And the defense obviously has a problem with this. Now, they also have a problem with Jud Welcher, but first, let's talk about, and I'll show you the clip of what happened with the defense when they're arguing about this specific thing of Burgess now amending his report in the middle of a trial. They're going to be called maybe next week, this coming week or the following week. And now the defense has this new report. So take a listen and then we'll talk about it.
All right, so Mr. Lessie, I'll hear you. I'll hear you, Mr. Lessie.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Jud Welch, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until May, not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they have associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to get it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analysis. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA. It's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture.
All right,
that
let me pause it for a second, will you? I think I've seen enough. Is there anything else that's earth-shattering that we need to see? I'm assuming. Did she let it in?
Yeah, well, I just for completeness, I was just going to let Hank Brennan to argue, because Hank Brennan's response is that no, this is all not new. It's not an amendment. It's all old information. We're not doing anything weird here. And I mean,
Except
the only
new report that says new times, right?
yeah.
The
So
times are
there's
different.
a new report.
Do they agree that the times are different?
He agrees that the times are different on the report. Yeah.
Okay. And the judge, and ultimately, is the judge letting it in?
So the judge ruled on this the next day, saying that she does not find that it's a Rule 14 violation, which is just another name for a discovery violation. And she finds like it's just kind of like, I guess, more explanation of his original report. So therefore, she doesn't find like this is new information or new reporting or new anything, and she's allowing this testimony in. So the two issues here is, was there a violation of the sequestration order? Because he had all this information already before. Like, why do you have to wait till May 11th after Ian Whiffen testified already? You know, Ian Whiffen's report was already available to him. Like, what, you know, is there a violation of sequestration order? And if not, what's this amendment? Well, what are we calling it, an amendment of report? If it's all the same information, you're just going to explain a little bit better. So what do you have to file another report? So yeah, tell us your thoughts about this and what the ruling you think should have been.
This is very interesting. My thoughts on this are twofold. Number one, this absolutely seems violative. Okay. I mean, there's two major problems with this report. Number one, it certainly looks like there was a violation of the sequestration order, because why else would he be changing his report after hearing Ian Whiffen's testimony if he didn't know what Ian Whiffen's testimony is? And just so your viewers know, a sequestration order basically means that a witness in a case is not permitted to know what other witnesses testified to. That's what sequestration means. If this case was not being streamed on every YouTube page and every news station in the world, then no witnesses would know what other witnesses said. All right. And then they'd come into court and they would ask, do you know anything about this case? Has anybody told you anything? Are you aware of what other testimony is? And their answers will truthfully be no, generally speaking. But it's not proper for anybody, a party or a lawyer, to tell a witness who's going to testify what other witnesses testified to, because that violates the sequestration order. So it certainly indicates that that may have happened here. That's number one. Number two, there's the trial by surprise. Experts are not permitted to change their testimony on the eve of trial. Even as you lead up to trial, if let's say you have a case where the prosecutor put forth an expert and then the defense makes experts or has their experts write their reports based on the prosecutor's reports. Then the prosecutor's allowed to do something called a rebuttal report, but to change their initial report really prejudices the defense because the defense kind of formulated their case around what the initial reports were from the prosecutor. And I'm often the plaintiff. I'm usually the plaintiff in a case, as you are. So we're usually on the prosecutor's side, even though we're not prosecutors, because the plaintiff goes first. So we'll submit our reports. The defense will look at them and then craft their reports based on what ours are. And then if we want, we can do rebuttals. Sometimes we do, sometimes we don't. But to do this in the middle of a trial is highly improper. And it's absolutely trial by ambush. For those two reasons, this should not be allowed. However, that said, I do not agree at all with the defense is doing here. If I'm the defense attorney in this case, the way I would handle this is I would take those reports, I would acknowledge receipt, and I wouldn't say a word. And I would let the guy testify. And I would see if Hank Brennan even brings out the fact that he changed his report. Because I think that if they wouldn't have made a big deal about this, Hank Brennan, this is just based on how I've seen him present the case so far. He has not been good about presenting both sides of the case. He only presents his side, and then the defense is able to just ground and pound and punch holes in the prosecution's case because there's so many things that Hank is leaving out, which, again, I've commented before, I think is a big mistake by the prosecutor. So again, if I'm the defense attorney in this case and that happens, I think the strongest thing to do, rather than exclude evidence, is prove that the evidence that's being presented is not credible. So what I would do is I would take the report, review it, notice the change, not say a word to Hank Brennan. Just send a reply email that says something to the effect of acknowledged and received. Thank you. See you tomorrow. Then I'd wait for this guy to get up and testify and see if Hank even brings out that he changed his report. Then in cross-examination, I'd completely shred the guy. Show that there's two different reports, that it's changed based on what Ian Whiffin's testimony is, and that it's done to, I wrote down what you said, align with Whiffin's analysis. Are you kidding me? You're going to go and modify your report? Did you watch Whiffin testify? Why'd you suddenly change it? You know there's a sequestration order. And again, we'll probably get laughs and smirks from the jury because they're going to know that no matter what the answer to that question is, it's probably not truthful. So my answer is kind of twofold. Number one, there's no way this change should be allowed once the defense brings it up. Number two, if I were the defense, I wouldn't have even brought it up. I would have used it as part of my cross-examination.
Yeah. Well, I'm sure we'll see that in cross-examination by Alessi. So moving on to another question here from Clara 4. Where are JLK's socks? Autopsy photos show them. Love from Tennessee. That's a question. We always get a question about the socks. I mean, there hasn't been a live stream with Solomon that we're asked that question. Where are John O'Keefe's socks? We see at least one sock in the autopsy photos, and in the evidence bags, there's no socks. I don't know. I don't know. Maybe Turtle Boy knows. I don't know. Pro Gamer gifted 10 Brother Council memberships. Appreciate that. Here's another question from LBL. Do you think defense needs to address Karen's clips or by their CIC case in chief? Case in chief. Or by their case in chief, other witnesses provide enough reasonable doubt. Okay, so here's a question that we always get also on this channel a lot. You and I think we've spoken about the rule of completeness, and Hank Brennan's selecting some of these clips to play. They're like 5-second clips. You're not seeing the entire interview. I said that I think if it was me, I would demand that the only way these clips come in is if the entire interview is played beginning to end. The entire docuseries has been played beginning to end because it adds context to the substance of what she's saying in these clips, and it's a violation of the rule of completeness. And I don't know what we haven't heard any argument about it. I haven't seen any argument by I haven't seen anything in writing or an oral argument about this specific issue of rule of completeness. I don't know what the defense is going to be allowed to do. Are they going to be allowed to cherry pick clips or not? What's your take on these clips? What would you do if you're the defense? Just give us your thoughts about these clips being played.
The clips are not good. Okay. And I think the fact that she stopped talking is a good thing for her. The reason they're not good has nothing to do with evidentiary value. It has to do with how unlikable she comes across. All right. Until she spoke in those clips, I didn't know how she sounded. All right. Now, obviously, I was late to the party here. I watched this case much later than you did. You probably heard those clips and saw her speak publicly. From the time the trial started, I did not hear her speak until I saw those clips. And she does not come across as likable, and she does not come across as somebody that you would feel bad for. Okay, so major points that she's losing there. If I'm the defense, would I want to play the rest of the clips? Well, you're entitled to, under the rule of completeness generally, what you're allowed to do is, if somebody plays a clip or a small portion of a statement that's made, you are permitted to introduce the rest of it at the time that it's played. Okay, that's the general rule of completeness. It's possible in this case, there's one of two possibilities. Number one, it's possible that the judge is not allowing the defense to do that, which wouldn't shock me, sadly, even though it's completely wrong and against the law. The other thing would be that the defense just doesn't want to play anymore. It's possible that they've heard, I'm assuming that the defense team has watched the entire video beginning to end, and they don't think it gets any better. And if it doesn't get any better, why play it? Why do it? Sometimes, this is just the reality of it, and you've seen me deal with this, and I've mentioned it a little bit to your viewers. When there's bad evidence or bad facts, you got to bring them out. So they were brought out. They're out there. They're in the trial. I don't think they do as much damage to her as the prosecution thinks they do. They certainly don't help the defense, but they don't prove or disprove her guilt beyond a reasonable doubt. So,
Yeah.
I mean, if I'm the defense in this case, I would just say, you've got these clips. She's talking about it. It proves nothing. That would essentially be my goal with those clips.
Yeah, I think that there was some discussion about the defense wanting to play some of the clips, and there was like a small mention during court one day where the defense said something about it, that we're going to play some clips, or some suggestion was made, and Hank Brennan kind of made an objection about it, and then this is where we get all these questions from, and like I said, I think it's an issue that we haven't seen them argue about. Maybe it's a sidebar issue, but yeah, I mean, it's definitely, the defense should be able to play the clips that help them if they feel that way. But yeah, so let's move on to this question. Elf, did you see the microdots video at the waterfall and the video of Higgins going back to the police station? Okay, now I don't know if he's talking. I see the entire trial. So the entire trial, everything that you see, I saw. So yes, I saw the picture, the video of Higgins going back to the police station. It's very suspect. What in the world is he doing there? Why is he moving things from his different trucks into his Jeep? Looks like at one point he has a bag. He's on the phone, either checking a voicemail or ordering pizza or making a phone call that's not great. That's incriminating. Yeah, so I saw that video of Higgins. I don't know if Solomon did, but the microdots video, Solomon, you probably didn't see the microdots video. I did see it. I saw the way that they analyzed the waterfall video. It's interesting. There's a lot of commentary there, and that's definitely their take on what was going on that night. And I can hear how other people would maybe interpret it differently. But it's very interesting. I mean, I saw it, and it's interesting, and we all saw the video in trial. But you're not going to get his commentary on that video introduced into trial. Zeeb, Judge Canoni allowed all Commonwealth voir dire, but never defense. Does that equal bias? So one of the things that the defense asked here, Solomon, was that they should be able to bring in Burgess and voir dire him about whether he violated the sequestration order. And Judge Canoni said, no, we're not allowing that. You can cross-examine him when he's on the stand in live court in front of the jury, but we're not doing a separate date for voir dire. So here's another instance where some people are suspecting that there's some bias here, where she's making the defense go through a lot more things than she's making the Commonwealth.
Frankly, that's something that if I were the judge, or I'll say it this way, that's something that I would expect the judge to do on her own. When presented with this sudden amendment based on Ian Whiffen's analysis, I'm surprised that the judge didn't say, I want him here tomorrow at 9 a.m. Put him on the witness stand, swear him in, and say, did you violate my sequestration order, yes or no? Do you know what Ian Whiffen testified to, yes or no? And then at least you have the answer. But I'm kind of surprised that the judge isn't doing that. But if she's going to let it come out in cross-examination, that's fine. I mean, look, like I said, I already told you what I would do with this. I would not have even moved to strike this expert or to. I think it's great. I think the more all this does is create more doubt. Why are the experts suddenly changing their reports in the middle of the trial? What changed other than Whiffen's testimony that you supposedly don't know about? What changed that you're now suddenly changing your report? I think that's a much stronger argument to make than just
Right.
trying to get something struck.
Here's from Helen Lewis. Thank you for the fantastic coverage, lending your time, wisdom, and experience, and helping us to understand the rulings in this case. Credibility is always an issue. Great point, Solomon.
That comment must be directed to you.
Jay Coop, I agree, but what if, God forbid, she's convicted? Shouldn't they have something on the record?
Very good question. And this is something that as a trial lawyer, we're constantly dealing with strategy, and we're constantly changing our strategy as the trial goes. All right. Something sometimes happens during a trial. There was one particular case I worked on where I had an entire defense planned, and ultimately, when it came down to it, I abandoned all of it, and I rested without calling a witness. And that's because of how the prosecution's case came out. So, there's always strategy decisions that are made. And as a trial lawyer, no, I don't think you should stick everything out there. I think you should have a very specific strategy. And ultimately, sometimes you gotta make those decisions on the fly.
Mm-hmm.
When you're doing cross-examination, for example, you don't know exactly what the answers are going to be. Sometimes you hear something so absurd and you just say, okay, nothing further. Thank you. I've had that happen where I'll call a witness I'll have an entire robust cross-examination planned. I'll get up and ask the first question, and they'll give such an absurd answer. I'll say, let me make sure I understand your testimony. You just said this. Yes. Thank you. I have nothing further. I'll sit down. Because you got what you need.
Yep.
You got to decide beforehand, what are you trying to get here? And if you get it, sit down and stop talking. I heard that the hardest lesson every lawyer learns is when to shut up.
Yeah. You and I have seen this. I mean, like sometimes we're sitting together in the gallery, we're watching a lawyer, these two lawyers going up arguing about a motion, and the judge is basically agreeing with one of the lawyers, and that lawyer still continues to argue. Yeah. Like, all you can do now is ruin it for yourself. The judge is on your side. Just shut up. You'll win.
I'll give you another quick story. There was a case I had one time much earlier in my career. I was probably 2 years out. It was my client was being charged with perjury. I don't remember how or why. I just remember that was the case. And I was trying to get the case dismissed at the what's called the preliminary examination stage. It's the probable cause stage, where after the prosecution put on their evidence, I argued there was no probable cause. And it became clear to me that we were going to win. Okay, I just got up and I said, Your Honor, at this time we move for dismissal. I don't believe the prosecution has established probable cause. And I sat down. And then the prosecutor gets up and starts arguing. And the judge is ultimately arguing with the prosecutor. And my client is slipping me Post-its and writing points to make. And I wrote one Post-it back that I wrote, does it look like we're losing? And I handed it back. He's like, okay. And then the judge looks at me and goes, anything else? And I said, no, Your Honor, we request dismissal. And he goes, case dismissed. That's it. And I told the guy afterwards, said, the judge is clearly going to rule in our favor. What do I have to gain by rebutting every point the prosecutor is going to say? If the case is getting dismissed, it's time for me to sit down and shut up and let the judge dismiss the case. All I can do at that point is hurt the case because he's already dismissing it. So, Yeah, sometimes you got to know when to shut up. And that's a very important rule.
Yeah, something hard, but something lawyers have to learn to do also. Okay, Quita G, completely agree with Solomon. It's good impeachment evidence. This looks really bad for the Commonwealth if you have an expert changing his report after conflicted with another Commonwealth expert. Exactly the point Solomon was making.
100%.
Helen Lewis gifted 10 Brother Council memberships. Appreciate it, Helen. That's very, very generous of you. Helen's a great supporter of the channel. Appreciate it. Jay Coop, what's your opinion on Judge Cannoni's second ruling on Friday? Okay. Let's get to the second ruling now, Solomon. I know we're past the hour stage, but let's get to the second ruling. So the second ruling was the following. You will recall that there's a big issue about ARCA. And the ARCA issue is never going to go away until they actually take the stand. But essentially what happened with ARCA was Judge Cannoni said ARCA is allowed to testify. Not only are they allowed to testify for what their initial opinion and report and reconstruction, but on top of that, they got Jud Welcher's reconstruction and report, and then they ran additional testing, and they're going to also testify about why they disagree with Welcher. So aside from their initial report and their initial reconstruction, where they came to the conclusion that in the world of physics and science, this interaction could have never happened, now they're going to be able to take Welcher's whole report and his reconstruction and destroy it. And that's what they plan on doing by, doing their additional testing. Well, now Hank Brennan said, that's not fair. we want now Welcher to be able to rebut all the additional testing that ARC is doing in order to rebut Welcher. So they want Hank wants the last bite of the apple to say, now I get to call Welcher and say why the ARCA's rebuttal of Welcher's case or Welcher's opinions is actually not accurate either. So Judge Cannoni ruled that she is going to allow that in some limited form. She's not deciding exactly what the range is going to be quite yet, but she has to wait to see how the testimony from ARCA and Welcher come out. And then she's going to decide what Welcher can be recalled for to rebut what parts of ARCA's testimony. What is your opinion about that?
The judge made the right ruling. The way it works with experts is the plaintiff goes, the defendant goes, and then the plaintiff goes again as rebuttal. If the plaintiff puts on an expert, in this case, the prosecutor puts on an expert, the defense gets to put on an expert, and then the plaintiff gets to put on rebuttal experts. There's nothing wrong with that. I know that a lot of people were arguing this and saying this is yet another one of her asinine rulings, but it's not. She made the correct ruling here, much to the chagrin, perhaps, of many people who are on the free Karen Reed side. Okay,
well, Salmon speaking the truth and speaking your mind, so I appreciate that. I think everybody likes that. All right, another comment from Aquita G. Those interviews are unforced errors. Karen's ego is prominent, and I can see why she comes off as not likable. I think this presentation of the case is better for the defense, but Karen's words creates unnecessary confusion. And this is what everyone's saying.
100% correct. That's why you gotta be so careful when you speak, when you talk, especially if there's a case like this, which is highly publicized. You've got to be so careful about what you say publicly. Yep. Now, I understand that there was some sort of gag order on the lawyers, which we can argue about whether or not that was proper. But I certainly don't like the approach of having Karen Reed talk to the media. I think it's a big mistake. Yep. 100%. And by the way, I want to back up. There was something you said before with the ARCA experts. Something I think is going to be interesting, and I've mentioned this many times, and you've mentioned this many times, and it's something we've talked about many times. When you have bad evidence, bad facts, and they're going to come in, you got to bring them out, right? I would love to see what the defense does when they call their ARCA experts about the text messages that were deleted that they know Hank Brennan's going to bring out. Okay, there's all those deleted texts. You remember, you know what I'm talking about?
The deleted text from which ones you talking about? I'm not
between the ARCA experts and the defense.
Oh, yeah. I'm sorry. Yeah. Okay.
Okay. So there's all those deleted texts that happened. And one of the things that the judge said during her ruling, and we talked about this already, was that she's going to allow a very robust cross-examination. I think that was her exact verbiage. Yeah. Again, if I'm the defense attorney there, I would bring that out in my presentation. I would ask him all about his case. And I would say, now you and I have been in communication after he's done testifying. And solidifying the defense in this case. Very strong testimony. So now you and I have had conversations and we've had text messages, and some of those text messages were deleted. Can you explain to us why? Why would you have deleted those text messages? Where are they? Why were they deleted? And then that way, when the prosecution gets up and starts hammering on the deleted text messages, the jury's sitting there yawning, saying, yeah, we know about this already. And that's why it's so important to do this. And Hank Brennan has not done a good job of this, in my opinion. I've said that before. And we'll see how the defense does it. Yeah. And we'll be able to compare and contrast. If the defense doesn't bring out those messages, I think they're making the same mistake that the prosecution's making. Yep. But we'll 100%. See how he deals with it. I think he's going to bring it out.
100%. I think I agree with you. Like always. Jody Arrington, new member. Thank you for that. Mr. Meathook, my sister, a lawyer, says every lawyer should read the book Getting to Yes. They know when to sit. Maybe also to be quiet. Familiar with that book, Solomon?
No,
me neither. Getting to yes, but I guess it's about getting what you want and then being quiet and stop and just learning to be quiet. All right. Well, I think what we're going to do now is let's see. There's one more questioner or comment. Please pass the pepper. Yin and Yang. Thank you for the straight talk, counselors, and Counselor Solomon, spelled with a C-I, of course.
I don't think that's a typo. I think that was done intentionally.
Or we can say maliciously. Okay, well, Solomon, looks like we've gotten over the hour, and I appreciate you giving us the extra 10 minutes today. I know that today's a special day. I know you got a lot planned with your lovely wife, enjoying your anniversary. So we're going to let you go. So I'll just give you one last, word out to say goodbye, and then we'll take you off.
Goodbye. Thanks for
Short
having
and
me
sweet.
again. It's always nice to be here.
Short and sweet. Thank you, Solomon. All right, everybody. So that's Solomon. That's the national trial lawyer. He speaks his mind, straight to the point. Whether you like it, whether you don't, you get what you get with him. So we will be right back here tomorrow morning for the live of Karen Reed's trial continuing tomorrow. It's going to be day 18 in Karen Reed's trial. So we will be right back here tomorrow, 9 a.m. for the live stream. And of course, all the recaps that have to follow the day's trial. So thank you all for joining us this morning. It's a lovely Sunday morning. There's a beautiful day outside to still spend the rest of the day. And if you get really tired, you can, of course, binge watch some of the Old Brother Counsel recaps and all that. Get caught up on the trial. And thank you all for joining us. We will see you next time tomorrow. And, of course, we'll see you next week for hopefully another stream with Solomon Radner. Take care, everybody. Thanks for joining.